Good afternoon, everyone. Welcome to our homecoming tradition of CLE ethics for you to hopefully finish out your credits for the year. How many this will finish out your credits for the year? Okay, awesome. Now, when I started as alumni director here in March of 2019, they told me we had this homecoming tradition where folks would come out before the barbecue and before the game and listen to a lecture. I thought, for real? This really happens. I was so amazed, and every year I'm more amazed by our alumni. How many are here from the 70s? Thank you for being here. 80s, yes. 90s, we got representation. 2000s, 2010s, 20s, there we go. Okay, well, we, without further ado, we will turn it over to our panelists here. Violeta, if you would take over from here. Do you have a mic?
I think so. Okay. Yes, there it is.
Perfect.
It's working. Thanks, Georgette. Hi, everyone. Happy homecoming. Welcome back to campus. Thank you for coming to the law school. My name is Violeta Chapin. I teach our immigration clinic here at the law school. I've been on faculty for 16 years now. And was actually hired to teach the criminal defense clinic. I replaced the legendary Pat Furman. How many here know Pat Furman from the criminal clinic program? Yes, I love it. So for at least 5 years after I got here, everybody called me the new Pat Furman for a long time. So I graduated from law school in 2002. I went to law school on the East Coast at NYU. And I then went to the Public Defender Service for the District of Columbia, where I was a public defender for 7 years. I thought I was going to be a public defender forever. And then we had a baby. And I was like, I don't know if I can do homicides all the time, every day. I was one of the few Spanish-speaking lawyers at the Public Defender, so I started getting more and more Spanish-speaking clients. And sometimes those clients weren't citizens of the United States. And so I needed to learn about the immigration consequences of criminal convictions when I was at work. So the clinic really mirrors sort of where my interests and expertise have taken me. We represent non-citizen clients in a wide variety of legal matters. We represent them in criminal cases. Right now we're handling 6 misdemeanor cases from the Boulder County Public Defender. All of our clients are non-citizens in some way, shape, or form. And the students are learning to represent their clients ethically, zealously, and competently in court, in line with their obligations. The truth of the matter also is that most immigrants don't commit any crimes, and so we do a wide variety of straightforward immigration matters, and that has ranged from working on asylum cases to handling special immigrant juvenile status cases, which I get to do with my friend and colleague, Colleen Robinson, who teaches our juvenile and family law clinic here at the law school. We handle cases that have to do with family-based adjustment. Love adjusting through your spouse. We'll talk a little bit about that. We handle some employment-based visa cases. And this semester, I will be very honest with you, our practice is a lot more stressful. And it's a lot different than what it's looked like in the past. There's been some, I'm sure some of you are paying attention. There's turbulent times right now in the immigration system. So it's a particular time to be teaching immigration law. It's a particular time, I think, to be teaching law at all, when it seems sometimes like our system is in peril. I see some head nods. So I would love for my other panelists to talk with you as well. You saw, I hope, some of their bios. To my immediate left is Brenda Torres, Ortiz Torres. Hunter Parnell is my student, my former student from last year. And what we're gonna do is sort of run it in a panel way. I'm gonna have some questions for each of them, and then they may have some questions for me. And I'd be happy to have you guys raise your hands and interject if you have questions that come up. We'll also leave some time at the end for all of you to ask questions. I hope this can be more of a conversation. So Brenda, we've read your bio. We know a little bit about you. Can you share with us how you came to know about the immigration clinic and how the clinic has been helpful to you over the years?
Yeah, so I came to see you as an undergrad in 2013. So that was when essentially like DACA had just been announced the year before. My family and I, like my brother, helped us fill out the DACA application on our own. And then when coming here, there was a specific person who worked in the, I forget what the name was, but his name was Dave Aragon.
The Office of Diversity, Equity, and Community Engagement. CU likes very long titles.
Yeah. Yes.
For the names of departments.
Yeah, and so he connected me with other students who were also undocumented. And through that, we got to know Violeta as well. And then the clinic started offering support in helping us renew our DACAs as well, and helping students apply for DACA as well. And so I was like, yes, of course. Like, why would I why would I try to do this on my own when I'm kind of like afraid of the government? I'm afraid to do something wrong on this because I don't want it to be denied. And so if I can be with somebody who can help me and who knows how to do this and who knows the language of the law, that would feel a lot better. And so from 2012, 14 and on, is when I started like going to the clinic for support with DACA renewals because I had heard that they were helping with that. And then, is it okay if I talk about like the rest of those? Yeah, sure. And I've been like connected with them ever since. Not only for DACA renewals, because now I'm doing my doctoral degree here at CU as well. So I was still getting help from the clinic with my DACA renewals. But also, then I got married to a U.S. citizen. And the clinic was gracious enough to like offer their services to us to apply for the green card application. And so we went through that process as well. And my parents saw how helpful the clinic has been and how much Violeta has just been amazing, and how hard the students work in the clinic to ensure that the people who go to the clinic are like supported and learn about the processes. And so as soon as they were able to, they also kind of moved their cases to the clinic and wanted the support from the clinic as well, because it felt really humanizing and supportive. So that's how we've been connected.
Thank you, Brenda. Yeah. Just a little bit of background in terms of what DACA is. How many people here have heard of DACA, Deferred Action for Childhood Arrivals? Awesome. It was created by President Obama in 2012 after the DREAM Act. How many people have heard of the DREAM Act? How many people know that the DREAM Act does not exist? Right? The DREAM Act has been introduced as a bipartisan piece of legislation at least 19 times, and it has failed at least 19 times. President Obama created DACA in order to have a program by which undocumented young people who came here when they were very small and have grown up in the United States are able to sort of essentially be deprioritized by the United States government for removal. And so in 2012, DACA was created. It never provided any immigration status to anyone, but if you came out of the so-called undocumented closet and presented yourself to the United States government and you met some eligibility requirements, you would be protected from removal, you would get a lawfully issued Social Security card, and you would get a work permit for the 2 years that you had DACA and would be able to renew it. We have learned, obviously, that DACA is fragile. Right? It's right now in the middle of a huge court battle. It's sort of limping along. It's sort of dying a death by 1,000 cuts, and we'll see what this Trump administration does with it. But whenever I meet a young DACA recipient, and now we have undocumented students that are enrolled here at CU, right? It's not an insignificant number of undocumented students that are enrolled at CU. And we have been helping them to renew their DACA, and I also get super nosy about their love lives. I'm always asking them, I'm like, are you dating anyone? And if you are, is that person perhaps a United States citizen? Because then we could help you go through the family-based adjustment process, which would lead to a much more secure space here in the United States and be a lawful permanent resident and a green card holder. So we were delighted to help you with that. Thank you for getting married to Clayton Dewey Dexter. Yay. So Hunter, you are now a third-year law student here at CU. You were enrolled in my immigration clinic last year for the year. Can you share with us why you chose to enroll in the immigration clinic as a second-year law student, and why or how that experience was important or meaningful for you?
Yeah, so I came to law school specifically to be a public defender. I come from a very large Chicano family out here in the state of Colorado. Unfortunately, despite the fact that my great-grandmother had 8 kids, 23 grandkids, 35 great-grandchildren, and 2 great-great-grandkids before she passed away, no man had ever graduated college in my family until I did. Nobody had ever gone to law school until I did. A lot of people have interacted with the legal system. People from municipal court to the feds. Somebody has been arrested in my family for a crime. You could name a couple, and I could tell you they probably did it. So I always wanted to be a public defender for that reason. But because I knew I wanted to be a public defender, I think a lot of people come here who want to do criminal defense or specific type. They'll track to the clinic that is most closely aligned with that. I knew that I would get opportunities to go do criminal defense work. All my internships, I've interned with the Colorado State Public Defender, municipal public defenders in Denver and Aurora, and I'm gonna go work at the Aurora Municipal Public Defender. But I knew that all of my clients coming from a family like this, very often, their biggest issues weren't their criminal case. Their biggest issues were inability to get mental health treatment or to access housing or having job problems. And I knew that to be a good criminal defense lawyer, I needed to know more than just about criminal defense. So given the opportunity last year between the criminal defense clinic and this clinic, I decided to choose this clinic because I really wanted to have a better understanding of immigration law and how it impacts our clients, especially after working in Aurora, where I would say a third to half of the cases that I was working on in my 2 stints as an intern there, had immigration consequences. And then once I started to take immigration law, I realized that it is a cluster. It is so difficult to make heads or tails, and there's always an exception for this rule and that rule, and this exception doesn't apply in these sets of circumstances. And I realized very quickly that I think it is nearly impossible to be a really effective criminal defense lawyer without having a very good understanding of the immigration system, because it is so easy to get something wrong when you're advising a client. It is so easy not to necessarily understand the full consequences that can come of a plea deal, which is, as all of you know, plea bargaining is criminal law. Because of the pace of public defense and the workload requirement, I think that seeing firsthand with a small workload, with an ability to do the extra statutory research and to dig into the case law and to have a professor who knows this stuff, I realized that public defenders, not just in Colorado, but around the country, don't have the tools they need to really fully grapple with the immigration consequences. And I was very grateful to see it, not just on the criminal side, but also the civil side. To be able to help people with family-based adjustments, with asylums, because now I at least have some understanding of some of the other things that my clients might need outside of their criminal case, and I can give them a little bit more informed consent of where can they go, what can they look for, how can they work on those other cases. So it was really impactful, I think, for my ultimate goal to be a public defender. I'll say this, as somebody who wants to be a public defender, I don't know how immigration lawyers do this stuff. It is so much more frustrating. Immigration court doing bail arguments is a kangaroo court. It's everything goes, everything is stacked against you. And even as somebody who is like running to go work in criminal defense in Aurora, Colorado, I don't know if I could do immigration full time because it was just very challenging. And I have immense respect for people who are able to do it because it's a lot. It is a lot, especially in these times.
So let's talk about ethics for a little while, Hunter. Rule 1.1 requires lawyers to provide competent representation to their clients. And we learned about the case of Padilla versus Kentucky, which was decided in 2010 by our Supreme Court, which now ties the Sixth Amendment duty to informing clients about the immigration consequences of crimes. This case was decided quite a while ago now. We are now in 2025, 15 years ago, and still, I would call it a crisis in American defender offices as to the competency that lawyers have with respect to Padilla advisements, even though now I believe that is a required cost and offices should be doing it. How do you think we should address this crisis, Hunter? You spend a lot of time talking to public defenders in other states. Do you see other states doing this better than we're doing it here in Colorado? How could we improve and really meet our Padilla obligations here in the state of Colorado better?
So I think the first, the gold standard in this is, I don't know if everybody has heard of a term called holistic public defense. Has anybody ever heard of that? No, a lot less hands on that one. Okay. So the holistic public defender idea was started out in the 1980s in Roxbury in Massachusetts. And the idea was that kind of what I said about my family is that the four corners of the criminal courtroom are where a lot of people, where we as criminal defense lawyers, public defenders think this is all I need to do. I need to win my motions, I need to go to trial, and once I do that, my work is done. And in Roxbury, and then eventually at NDS Harlem, the Bronx Defenders, Legal Aid Society, they realized that no, actually, we need to be providing more than just criminal defense to our clients. We need to be giving them access to tenant defense. We need to be giving them access to immigration defense. And New York has actually made it that you have a Gideon right to counsel in non-criminal matters. So if you have tenant defense and you can't afford counsel, one will be provided for you. If you need immigration defense and you cannot afford counsel, one will be provided to you. I think a lot of people wait for the federal system to tell us what is gonna come, but we can just do this in our states, in our local governments, in our communities. And we don't actually have to wait for the Supreme Court to say, you have the right to counsel in these other matters. And I think that the places that have expanded the right to counsel, there are other states who have done it in various different forms, but New York is probably the one with the biggest immigration practice. They're the ones who are doing the best, because I don't actually think that your public defender fresh out of law school in county court here in Colorado with 220, 250 misdemeanor cases, I don't know if we can actually get them up to speed on all of immigration matters in a meaningful way because of the pace and the caseload they have. But if we just had the right to counsel for immigration defense, I think we could kill two birds with one stone, because we could take a burden off of the criminal defense lawyer who has enough on their plate and actually ensure that the person that they have access to is qualified to do so. We would not be the first state to do it. We won't be the last state to do it. But I think that that is the biggest fix that can come, because quite frankly, here in Colorado, I believe it's 2 people who are advising for the whole, 2. We have 2 people doing Padilla advisements for the whole state. I don't think that's enough. Not given where we're at, not given what we're doing, not given that this administration has targeted Denver, where I live, as a sanctuary city. I think that we need more, but then every time you say we need more, well, are we taking funding from the public defender agency? It becomes a challenge. So I think it is just easier if we as a state or a community commit to providing representation in these matters. If you can't afford it and you need it, we should be filling that gap, because now working in the clinic, I mean, some of the cases are relatively straightforward, DACA renewals, having worked on them. Those are pretty easy to do. The harder ones, the asylum cases, the criminal immigration, having a client who has a pending criminal matter but also has a deportation order. The fact that that criminal defense lawyer can only do so much, and there's only a handful of people that we can reach out to help us, I think that's because we're not quite meeting a real meaningful right to counsel like they are in some places.
Yeah. I'll say, when I first got here to Colorado in 2009, the statewide Colorado public defender system did not have a single person in-house who was advising about immigration consequences of crimes. And for many years after Padilla was passed, they didn't have someone in-house who was doing it. So we had non-citizens across the state that were not being represented in line with ethical obligations by their lawyers and competency obligations. They just weren't. So Doug Wilson was the chief of the public defender for many years. Megan Ring was the public defender here in Boulder for many years and is now the chief. How long has Megan been chief? Probably 8 years? 10 years?
2017, 2018, around that time. So
since Megan has been there, they've now hired 2. They had Marnie Adams first, and I can't remember the name of the other woman who's doing it. But in my opinion, it's a huge improvement over what it was. but it's certainly not where it needs to be. We have a statewide system. We have thousands and thousands of clients, and we have so many lawyers that need this information in order to be able to ethically represent their clients. And it's challenging when you have those numbers. But the money is real, and for years, Megan was like, I can't possibly hire someone who's just gonna come into the office, not pick up a caseload, and just do immigration advisements. I was like, you have to though! And so it finally did happen, but it was a real challenge for her in the system. Brenda, I'd love if you could share with us a little bit about what your experience was like working with law students who are obviously not yet lawyers and are still learning. That's part of the process, is for them to be sort of mucking their way around some kind of legal case in the clinic. And oftentimes, clients will observe that. They know that they're working with law students. I'd love to, if you could share with us sort of your experience working with students for DACA renewals, and then doing a more complex matter, right? A family-based adjustment petition. Was your spouse at all concerned about working with law students, and were there any sort of benefits and then challenges that you encountered?
Yeah, I think to start working with law students at CU Boulder, it felt humanizing. It was like the number one thing. I was like, oh, okay, like I'm a educator by trade, so I'm like a teacher, and so so seeing that there are students who like want to do this felt very humanizing for me, because it felt like, oh, okay, like there's people here who like want to support me, aside from seeing like what's on the news and on social media. Like there's people who don't want you here, and but then coming to the clinic where there's a classroom of students who are interested in these matters and interested in supporting community members felt really humanizing and supportive. I think the other piece is that it felt secure, that even though they are learning in their practice, they're still underneath like the law school, right? They're underneath, like Violeta still like checks in with the students, and so at least how I understood it. And so I was like, okay, yeah, like I don't believe that something incorrect on my application for whatever it is can go through. On that note, DACA renewals, like Hunter mentioned, are like super easy, I'm sure, for law students, because they're very straightforward.
I don't know, they're not super easy. Still got to do everything right.
Yeah, yes. And so they're a little bit more straightforward, especially if you've applied for DACA before. And in the later years of DACA, at least like a few years ago, it felt like it was more direct, where like the applications aren't changing so much, and so you can use a lot of the information that you had. And unlike the first time that you apply, you don't have to provide all of this evidence that you were here from this time to this time. And so so the renewals felt a little bit more like quicker, right? It was like, oh, we need this information, we need these things, bring in your employment proof, and it was like, okay, cool, I'm good to go. That felt really quick. Whereas when my husband and I, when he put in the petition for me for the green card application, that one felt like it was a little bit longer, right? So like we were asked to bring in certain evidence, and then I think the law students like learned a little bit more things of like, oh, we need these things now. And so so it felt still humanizing, where it's like, oh yeah, we're both kind of learning through this, but I'm still trusting that you know more than I do. And so there was a lot of trust that the CU Law School is holding their students up to a high standard of like, yes, we expect you to know how to do these things, and we're going to support you. And so, and I could feel that when working with the law students, where they felt like they were coming in with obviously more expertise than I have, and could answer my questions. But if there were ever questions that that they couldn't answer, they'd be like, okay, let me write that down and get back to you. And so it felt like, okay, no one's making things up here. It's gonna be like things that are known for sure. And my husband didn't have concerns working with the law school. He was really grateful, like, oh my gosh, this is an amazing resource that is here to support community. Like, he was really excited about it, and really the concerns came from, like, how is USCIS gonna take the application? And so.
Because USCIS, who knows what they're gonna
Yeah,
do? U.S. Citizenship and Immigration Services. Wah! It's if it was like limping along before, it feels like it's descending into chaos now.
Yes.
That's a lot of fun.
Yeah, so that was more of our concern. I felt a lot of like trust and support from the immigration clinic at the law school that they were gonna do right by us.
Thank you, Brenda. One of the things you said, which is that the students are there to help you and to be engaged in this space with immigrants at a time when America feels really anti-immigrant. You know, I was actually really concerned this year about whether or not any students would sign up for the immigration clinic. Not because they were feeling hostile towards immigrants, but just because the immigration system feels so chaotic and a little strange. Yes, sir.
Are students in the
Yes. So under the student, I have to put my sunglasses on because these are my prescription sunglasses, which have changed my life. But when I forget my indoor glasses, then I'm, hello. So yes, under the Student Practice Act, students have been able to practice in clinic under the supervision of a professor, and they can go into court. We've been here for many years practicing in county court and municipal court and family court, and we also stand up in immigration court, yes. So the students are appearing in federal immigration court in front of an administrative law judge, and their opponents are lawyers from the Office of the Principal Legal Advisor, who are the attorneys for the Department of Homeland Security. And that will be either at 1961 Stout Street in Denver or at the Immigration Detention Facility, which is where Hunter represented his client at a bond hearing last semester.
Yeah, that didn't go well.
No, he did not get a bond. None of our clients got bonds last semester.
Last year I did 2 criminal cases. Both we resolved via plea. One bond argument in front of the judge, and unfortunately, our client did not get bond in that. I also handled one asylum case for an Afghan refugee, and then a couple family-based adjustment status.
Yes.
Can I ask a question about DACA?
Sure.
Your initial comment, I've always wondered about that. Oh, I'm sorry. With respect to that, was that just basically executive orders?
Yes.
That controls the administrative process? And here's my question then is, considering how President Trump would be considered the soul of kindness towards people, why hasn't he just destroyed it all immediately with executive orders and sent Pam Bondi or one of these clowns down there to just stop it immediately?
Yeah, so that's a good question. So candidate Trump, before the first election, campaigned on the promise to immediately kill DACA when he came into office. He didn't immediately kill it, but he did try to end the program. If you'll remember, our Attorney General Jefferson, Beauregard, Sessions, got up there and attempted to announce that they were gonna wind down the DACA program. There was chaos. It was very scary for a month or so. It was immediately enjoined, though, in the courts. It ended up going all the way to the Supreme Court. But the question wasn't whether or not the DACA program was unlawful. The only question was whether or not the way that President Trump tried to end it, if that was unlawful. And we got a rare win at the Supreme Court in June of 2020. Yeah, it was like right in the middle of COVID. Right? I was like home, we've been home for months and we were all sad and depressed. But we won at the Supreme Court. So DACA has still been alive, the program has still been alive, but it's a good question, why hasn't President Trump killed it? Because in that Supreme Court decision, Justice Roberts gave out a very clear blueprint for how to effectively kill DACA. So here's my thing. President Trump, right before he got elected the second time, stated that he believes, first of all, and he said, I love the dreamers. He said that a couple of times. You never know. He said, if it was up to me, if you were undocumented and you graduate from a United States college, you should get a green card the day you graduate. 100%. I totally agree with President Trump there. His campaign immediately walked it back. But it is true that he hasn't killed the DACA program now. And what I've said this to a few people, now that he has Congress, obviously, in his pocket, he should pass the DREAM Act. He should pass the DREAM Act because I think politically that would lock up the Latino vote for the Republicans for a very long time. He would be able to tell them that the Democrats couldn't get you this, which is true. The Democrats could never get the DREAM Act through. It was a bipartisan piece of legislation, but it just has never happened. So they just recently filed, the administration just recently filed litigation, because there is ongoing litigation that is sort of stuck in Texas and the Fifth Circuit and is somehow gonna get to the Supreme Court. And that litigation, there's a Texas judge who has twice ruled that the DACA program is unlawful, that President Obama exceeded his executive authority when he created it. I think they're wrong, but they keep winning at the district court in Texas. It's this one particular judge who's a particular friend of theirs. The Trump administration just filed a brief in that court stating that they are intending to reopen DACA to new DACA applications, which is a big deal. We haven't allowed new DACA applications to be processed by USCIS for about 7 years. So we have a number of undocumented students who are enrolled here at CU. Like our last incoming 3 classes of undocumented students, none of them have DACA because they aged into it. You had to be 15 to apply for DACA. So they qualify for it otherwise, but they just weren't old enough. And so when they finally did age in, they haven't been able to submit a new DACA application. But if this happens and they reopen DACA, and given the court's ruling, their plan is to reopen DACA to new DACA recipients in every single state except Texas.
So your practice is essentially constant chaos, I gather.
There's new things happening every day, all the time.
Okay. Well, thank you very much for that.
Yeah. Hunter, can you talk to us about a particular case that you worked on in the clinic where you learned something about how our immigration system could be improved?
Yeah, so the one that sits with me, so prior to coming to law school, I graduated from the Air Force Academy, and I was in the military for 5 years. I was an intelligence officer. My dad he's still an active duty Army officer. He's 24, 25 years. So when I had an opportunity to work on an asylum case for an Afghan refugee, I was extremely happy to do so. That individual's family fought with my father, in Afghanistan, and I feel it is our obligation to help those individuals that we left behind. And working on that case and seeing how the government feels about that, I don't know if I can use all the words that I felt when I saw the way that the government opposed that. But as many people might know, I believe the Trump administration is moving to limit refugees to 7,500 with a predominance on white South Africans. And he has ignored our Afghan allies that we have left behind. Currently, right now, there's 1,200 Afghan refugees that are stuck at Al Udeid Air Force Base in Qatar that came over when everything fell, and they've just been stuck there since we pulled out of Kabul. Seeing how we treat individuals who have done it the right way, who have followed the rules, who have tried to do everything correctly, seeing how people who are in the middle of pending asylum claims are having those asylum hearings canceled and then picked up by eyes for deportation, kind of circumventing their ability to even raise asylum. Are people familiar with how our asylum program first got started, like why we have it the way we do? So at the beginning of World War II, there was a boat mostly of Jewish refugees from Germany who sought port in Miami and were denied access. They went to Cuba and were denied access, and then ultimately had to return back to Germany. And of the 500 or so people on there, about 300 to 400 of them were killed during the Holocaust. And at that moment was when we decided to make our modern refugee asylum process so that we didn't do that again. And unfortunately, we have seemed to have forgotten that history. Like my client feared real concerns that if he went back to Afghanistan, he would be killed. Members of his family had already been given asylum, and yet the government was still fighting it on us. So that sits with me, and then the bail, the bail argument. For those of you that don't know, in immigration court, the judges there are not judges, not really. They are not independent. They serve at the pleasure of the executive branch. At the beginning of this administration, many of those who would not just rubber stamp whatever the Trump administration wanted were fired or quit. And since then, when you go into immigration court, after working and doing, I've now done, a bunch of bail arguments during my time at the public defender agencies. And again, as crazy as criminal court can be, as hard as it can be to get a victory there, the immigration court, there was no chance. The Department of Justice was able to provide the day of our argument a previously unknown document that claimed that our client had certain criminal convictions, but it was just a piece of paper. It wasn't police reports, it wasn't records, it wasn't anything official. It was just, I have some information that says he's been convicted before, here you go. I had no way to verify that. When we went up there, everything that they argued was other forms of hearsay evidence. There's really nothing you can do but object to it. The judge is going to permit it to come in anyway. And our client at that time was out on bail in a state matter. So a judge in Colorado had already determined that he was not a flight risk and not a danger to the community. So that's what I told the judge. I was like, hey, somebody's already found this. You don't got to worry about it. You can give him bail because we have already said he's fine. And without stating why, she just said no. Denied. See ya. You're staying in custody. Would not hear our claims about issues with fear of torture upon return to his home country. And ultimately, as so many individuals do, opted to self-deport. And those are the two areas. It's just the way that the law is so inapplicable to such an important thing for so many people. That's what I would change. It's just that we would treat it like actual court, that rules of evidence would actually apply. I don't think that's a crazy ask, but that's not the way it is.
The immigration bench is really in crisis. We've known for many years that the immigration court system is the most overloaded system that we have. It has millions of cases that are backlogged, some of them for many, many years. And we have judges who have been completely overwhelmed. Add that to the mix that the Trump administration is firing a lot of these judges. They've been floating the idea of replacing them with some military law judges who don't know the immigration system. But what they've been really successful at doing during this administration is diverting people away from the legal system and ensuring that they don't go to court, doing certain things that ensure that people will just give up their rights and go home. Some of you may have heard they're offering money to immigrants to self-deport. They are changing things to make it such that most immigrants that are coming into court are not going to be eligible for bond, so that they're just simply giving up and going home if that's what they need to do. It's really been, and the level of fear is extraordinary because of some of these things that we're seeing, and certainly the deportation of people to countries that are not their own, where it's not sure that they're ever going to be able to be released from custody, where they don't have any family members, where they don't have any immigration status in those countries, is so frightening to people that I have talked to more and more people who are choosing to just sort of hedge their bets and maybe just leave on their own. I mean, it's really been extraordinary. It's been very effective to move people away and out of the legal process by a number of mechanisms. Yes?
So with Thanks. With deporting people to a country that's not their home country, what's the rationale? Is it because they have claimed asylum and therefore claim that it would be unsafe to go back to their home country, and so then they say, oh, well, we're going to send you to this other place? Or is it just performative cruelty and that's it?
So the Immigration and Nationality Act has actually allowed the immigration system to find safe third countries for people to be removed to from the United States. We just haven't done it for a long time because of some of the perceived cruelty of it. There's not really any way to ensure that another country is going to actually allow the immigrant to be released and sort of housed and given work authorization and to do all the things that would allow them to live a dignified life. So it just hasn't happened for a long time. So what's happening now is that the Trump administration is simply making use of that power, which has existed for a long time, and doing it. like pretty effectively, to such an extent that that it's becoming sort of normalized for it to happen. We have a case right now in the clinic where our client is originally from the Dominican Republic, and he was a lawful permanent resident here of the United States for a very long time. He unfortunately has a drug conviction out of New York from 2006. So he was deported, he was stripped of his residency, he was deported to the Dominican Republic, where he lived for about 15 years as a gay man. He was tortured and abused terrifically by the police in the town where he lived. We have mountains of evidence again about that. He escaped back to the United States. He's now been in immigration detention for 2 years. Because of his criminal conviction, he's not eligible, and because of his removal, he's not eligible to ask for asylum, but he can ask for something called withholding of removal. And here's the catch, which we've explained to him multiple times, and the students are trying to wrap their brains around, is that we could win this case. We could convince the judge that it is unsafe for our client to return to the Dominican Republic, where he would likely be tortured. They could grant withholding of removal. The problem is that they will then send him somewhere else. Now we know that they will use every mechanism they have not to release him. They don't want to release him back. They won't back into the United States. His mother lives in Washington Heights in New York, where all the Dominicans live. But they're not going to release him to mama. Right? They're going to release him somewhere else. And you know, all the reasons for why they're doing it, I mean, we're hearing things about, like there was a man who served a pretty long sentence in New York, who's originally from Jamaica. He was released, was out for a little while, but then was deported to somewhere in Africa. Meanwhile, the Jamaican government was like, whoa, 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 we would have taken him. Right? Why did you send him to Africa? And then Jamaica had to work with the African country to get him back to Jamaica. It required sort of, you know, diplomacy between those two countries to do it. But you're wondering, like, what is the administration doing? Why didn't they just facilitate his return to Jamaica? Like, why send him to Africa for any other reason other than to just be cruel? Yes?
I just wanted to people back too, right?
Sure.
And so they're getting sent to third countries.
Right. We've had some clients who weren't able to be refused, they weren't able to be returned to China, for example. China hasn't, and the United States are not playing well. But for whatever reason, China has refused for a while to take deportees, and so most of those people were then, even if they had an order of removal, they were released just out into the United States. They're now being detained, and the administration is thinking of other places to take them. On the other hand, there's a lot of countries that are signing up to take people because the Trump administration is offering them a lot of money to do it. Perhaps one of the most infamously is the country where my mother is from, which I dearly love, and that's the country of El Salvador. President Nayib Bukele has created a gigantic prison in El Salvador that some of you may have seen. And the Trump administration is paying him millions and millions of dollars to take deportees from the United States and house them in the facility in El Salvador. Did you have a follow-up?
I'm an immigration attorney, so I have these questions, but
Yeah.
Doesn't El Salvador still have TPS?
Yes.
And all the other countries?
It helps, right? It's been beneficial for Nayib Bukele. And so TPS is temporary protected status, which is very similar to DACA. It's a temporary program where people can apply for protection from removal, and while they're here, they won't be deported, or while they have TPS, they wouldn't be deported. They get a social security number and a work permit. And El Salvador was designated for TPS in 2001 after 2 hurricanes hit the country, one right after the other. It made it impossible for Salvadoran nationals to return back to the country. So El Salvador, the country, has to be designated for TPS, and then Salvadoran nationals here in the United States were able to get TPS. And yes, El Salvador has had TPS for over 20 years now. And President Trump is right when he says that the TPS program is not acting in the way that it was designed to act, because it's clearly not temporary if it's 20 years in. The Trump administration has certainly been ending TPS, famously for Venezuela, for other countries as well, but has not terminated TPS for El Salvador, I think in large part because he's friends with Nayib Bukele. Did you have a question? Oh, yes. Hi there.
Hi. I worked in the court system in different capacities, and I can tell you that judges and prosecutors and defense counsel all would like to give proper Padilla advisals. Yeah. And my question is that we have grids. And the sentencing scheme is complicated in Colorado. You've got extraordinary risk crimes, you got mandatory crimes, you got crimes of violence, and the grids are sometimes complicated, but we can give pretty good advisals, accurate advisals. as to what sentencing ranges are and outcomes. We can give advisals on, we have grids for implications in departmental vehicles, implications on collateral consequences. Why is there not a grid that we get in the criminal courts to give advisals on the Padilla issues? Is it because it's unclear?
So the problem is what you said. It's called the categorical approach to determining whether a criminal offense falls under the specific inadmissibility or deportability statutes, and it is arcane. It just is so difficult to actually determine whether or not something qualifies or doesn't qualify. You don't actually look at the individual facts of the specific case when you're doing the categorical approach. You're just looking at the statutory language itself. And I think that just quite frankly, it would take an immense amount of time to go through each individual statute. And then you have like where I'm at in municipal court, you know, Aurora City Council. They have passed several mandatory minimums for petty theft that are currently, you know, facing challenge at the Colorado State Supreme Court. Most places don't consider municipal violations, but because we're up to 364,
Right.
a couple of these might be crimes of moral turpitude. The INA is so vague that I think that the answer is much more practical and pragmatic. Somebody could do this, but every single time we change our criminal code, well, now we're gonna have to redo this analysis with every single one. And I think that just quite frankly, most people aren't prioritizing it. Unfortunately, because it could be done, but it would be a Herculean effort to go through and do the categorical approach to every single possible offense that could be charged.
Right, but then I guess my response is then you can't be too critical of the courts or defense counsel or prosecutors in not being able to provide precise information if there's not precise information to provide.
Oh, well, they can certainly learn it. I mean, so now that it's a mandated cost, right, public defender offices do need to know about this. There's no duty on the judges or the prosecutors because they're not advising clients. The duty is on defense counsel. And so they can certainly learn it. And I spend a ton of time training public defenders about immigration consequences of crimes. They're certainly trying.
And I think they do a good job. I've taken pleas for the last decade, and I've seen them actually trying. So
for sure.
I'm not necessarily arguing with you that it can't be done better.
Yeah.
I'm just saying that the courts are trying, the defense counselors are trying. I think, to be honest with you, judges and prosecutors want proper advisals because if we don't, the cases can come back again.
Certainly.
And so there's a certainty. I just thought the answer is one you gave.
Yeah.
It is that it is so complicated that it's almost impossible to have some standardization without having that individual case looked into.
Right.
And the other question I had is, does it also depend on the status of the person?
Yes.
As to the consequence, I mean, that's the other thing is what their status is, probably whether they had prior offenses, I think, is, you know,
Absolutely.
I mean, so I just wanted to toss that out there when we're talking about the courts and people trying to do comply with Padilla for the last over a dozen years now is that I don't think there's a resistance to us. I just think there's a complication to it that lacks clarity of advisals, including collateral advisals in other cases.
So I agree with you 100%. It's very complicated, but it certainly is not something that some lawyers can't learn, right? So there are experts in this particular area, and the idea is that public defender offices need to have access to those experts. We don't ask for every single line public defender to become an expert, right, on immigration consequences of crimes, but you need to have someone in-house who does know these things and understands the complexity of it and can give these advisals to the lawyers, so that then they can learn and then talk to their clients about it. So I agree that, you know, there has been I've been delighted with the effort in Colorado to try to get on top of this. And I'm also grateful, you know, there are some elected district attorneys who tell their prosecutors that they are required to talk to defense counsel about the immigration consequences of crimes and to try to negotiate a disposition that doesn't have unnecessary immigration consequences if it doesn't need to have that, to just be aware of that so that they're making informed pleas. And certainly judges who are asking us for information about what is it that we can do as judges to ensure that people understand their rights. Sorry.
Can you explain crimes of moral turpitude a little more clearly? Because a lot of the cities I work for change it from 365 days to 364 days, thinking that, well, it's not a year, so we're all good.
Right.
I seriously doubt that.
So the 365-day calculation applies to whether or not something becomes an aggravated felony. which is the Death Star in immigration court. Crimes involving moral turpitude often doesn't matter what the sentence is, it's just whether or not something is morally turpitudinous or not. Right, I don't know, right? Like, what's hard about the crimes involving moral turpitude is that there's no definition of what that means, and so it's just sort of case by case, and what is it that we think is that? It's been litigated, it's one of the things that's been litigated the most up into the federal system, because what is morally turpitudinous to you, sir, may not be morally turpitudinous to me. It's very subjective, right, these things. So we've tried to come up with some rules about what makes something a CIMT. I mean, there's a wide variety of things that it could be, but that just goes to show how complicated it is. Yes?
So could you talk a little bit about the changing competence of the judges in immigration court? The only one I know was a former county judge that was removed by the people in the retention vote, then kind of washed out of the city of Denver as a hearing officer and is now an immigration judge because of a poor temperament in both of the removal incidents. But related to this question is maybe the clinic needs to, if there are vacancies on the immigration court, maybe reach out to CU Law alumni to encourage them to apply. So maybe somebody starts giving bail.
That would be awesome. I wouldn't wish anybody being an immigration law judge on my worst enemy. Oh my goodness. Those that are giving bail are getting fired, right? Hunter is right that the immigration law judges serve at the mercy of Pam Bondi and whoever is the in charge. So with respect to competency, so in my experience, most of the immigration judges that are sitting are coming directly from the Department of Homeland Security, and they were previous prosecutors in the immigration court system. They are required to have competency in areas of immigration law, which is complicated and they need to know it. In my experience, they're fairly good on that. It's just there's a lot of things about immigration law that take away discretion from the judges. So for example, if you've been convicted of a crime involving moral turpitude, or you've admitted to a crime involving moral turpitude and you're undocumented, you're not gonna get bond. The judge doesn't get to hear, how long you maybe have lived here and all the good things about you and hear your equities. You're just not gonna get bond under the statute. So there's tons of ways that immigration law judges don't have any discretion. And then there's lots of ways that they do. For example, when they're considering whether or not to give someone a green card because of their marriage to a US citizen, right? If those are in court, right, the judges have some discretion about whether or not to admit them into residency at the United States, and it's into the United States. It's very difficult to overturn that at the Board of Immigration Appeals, which pretty much for many, many decades has essentially rubber stamped the decisions of immigration law judges. So they have a lot of discretion to make some decisions, and then in other cases, not much discretion at all. I am worried about the dwindling sort of number of immigration law judges if they're going to be replaced by people who have no competency in immigration law, that this immigration system is going to descend even further into chaos than it is already. It's going to be very difficult for the attorneys representing people in immigration court. But the truth of the matter is, we've never, and they've heard me say this a million times, we don't have a public defender for immigrants in this country. So the vast majority of immigrants that are navigating the civil immigration proceeding are pro se. They just go by themselves. It's awful. So what would they know, really? More and more people are sort of coming into the system or are perhaps going to be able to find the money for an immigration attorney, but it's extraordinarily expensive. One of the reasons why we're so glad to offer this service that we have in the clinic is because obviously clinical representation is free, right? I've been lucky enough to be a free lawyer my whole life, and I love that. All right, we're gonna get back to asking some questions here. Oh, we've got a question, yes, I love all the questions. Of course I knew you would be an active lawyer audience.
One is a comment and one is a question. Sure. To your point about what brought about asylum, there's a movie called The Voyage of the Damned that deals with that, and it's actually currently showing on Xfinity. Yeah. It came out about 1970 or 72. It was the first time I saw that. Could you also address the provision in the Immigration and Naturalization Act that reserves to the Secretary of the State the right to determine whether somebody is a threat to national defense and whether you think that's constitutional?
So this is related to the attempted deportation of Mahmoud Khalil, the student at the University of Columbia, if those are unfamiliar with the case. But that, until this point in time, actually had only been litigated one time. The funny part about it is that the judge who determined that this statute was unconstitutionally vague was, is it Trump's sister or aunt?
Sister.
Yeah, sister. So she was on the district court bench in the 90s, and she determined that this statute, but it got overturned at the circuit for other reasons, and nobody had ever looked back at this. But this allows the Secretary of State, not a designee of the Secretary of State, but the Secretary of State to determine that a person can be removed because they are a threat to national security, or that they would impact our national security interest or foreign policy interests. What does that mean? I don't know. It's a great question. It is being challenged for void for vagueness. Unfortunately, there's a lot of things in the INA that are void for vagueness, i.e. the crimes involving moral turpitude. But in the 1950s, it was determined that that was not void for vagueness. So if you ask, I think, most people who practice law, the answer would be, this is a void for vagueness issue. There is no notice of what an individual could or couldn't do. There is no ability for a person to properly prepare for this. But unfortunately, because of plenary authority that has been granted to the federal system to deal with immigration, could I see this Supreme Court finding some way out of actually addressing the void for vagueness issue? Absolutely. They are also trying to get Mahmoud Khalil out on a number of different grounds. So there are things they're trying to go after his initial paperwork and say that he claimed fraud, which could get them out from this part of the statute. And that's kind of the biggest thing about this, is the way that this statute can be avoided is that the administration can just find another part of the INA to pursue. And that might be something they do. So is a statute like that void for vagueness? I think so. I think most people would say so. But do I have a lot of faith that that decision would be rendered? I don't know, because there have been other historical examples where vague parts of the INA were upheld perfectly fine.
This question and answer brings up the question of students and their enrollment here on campuses in the United States, both as international students, but also as undocumented students, and how it is that campuses both support and also protect those students. So Brenda, you navigated your time here at CU Boulder for many years as an undocumented student and as a DACA recipient. Were there times when you felt unsure, maybe, or nervous about disclosing your immigration status to any of your faculty here, or staff members, or even fellow students? And what was that experience like?
Yeah, when I first got here, right after DACA had been ordered, I felt a sense of confidence to be able to be more outspoken and more open about my status, because it felt like a really hopeful time. Like, oh, we're getting somewhere, right? This isn't a permanent solution, but there's something, which means that there could be more, that we could work towards more. And so I felt confident to want to speak out and to support my undocumented community. I also felt nervous to speak out for my family specifically. And so when I did speak out, it was more for general things and for myself specifically, because I didn't want my own confidence and willingness to be out there to impact my family negatively. Because while I had DACA and my younger brother had DACA, my parents didn't have anything. And so I worried about them a lot, because they were the reason why we were here. And they're the reason why I get to be up here today and speak to all of you about my experiences. And so I felt really nervous and protective of my parents, and felt like, oh, I'm fine putting myself at risk. I don't want to put them at risk. And then when the first Trump presidency happened, that's when I felt less confident being outspoken. There was an incident at CU where students started building a box wall and started chanting "Build the Wall." And that was a moment that really stuck with me and made me feel like, oh, maybe I can't be so outspoken, because this is more risky now. My fate is a little bit uncertain, and the fate of DACA was especially uncertain. Like Violeta said, that first time around, he campaigned on ending the DACA program, and so I felt really nervous to speak out, but that quickly kind of ended. I've always liked to be a little bit more outspoken and support for my community. I have felt a sense of responsibility to support the undocumented community in any way that I can, even if it puts myself at risk. And so when it comes to my own life and to my own experiences, I am happy to be out there in the front. What does make me nervous, though, is if I'm putting my family at risk by doing that. I don't know if there could be retaliation that would impact my family rather than me. And so that is really where my uncertainty comes in. And, yeah.
Thank you for that. So about 12 years ago was when I learned through David Aragon in Odyssey that we had as many undocumented students on campus as we did. And David and I paired up with a professor from the history department, Fred Anderson, love him. The three of us started, we actually learned, well, we started saying we need to have, David Aragon had sort of been quietly supporting undocumented students on main campus for many years, but there wasn't any institutional knowledge around undocumented students and their particular concerns. We ended up meeting a bunch of people from Colorado State University up in Fort Collins. CSU had been helping and working and supporting with their undocumented students for years. And we actually went up there to get a training for them for something that we did for many, many years here called UndocuAlly, where we go and talk to people on campus who likely will meet and work with undocumented students in whatever regard. So we met with financial aid officers who would need to explain to undocumented students, even if they have DACA, that they're not eligible for federal financial aid, and they need to figure out sort of another way to apply for things. We talked to people in admissions about undocumented students. We talked to people in career services about those things. And one thing that was really important for us to make sure that we emphasized to folks was that people's undocumented status, first of all, we need to create a space where they know that if they are undocumented and they have questions about it, that we are safe people, right, for them to ask, and that we have some knowledge about that. And so we offered these UndocuAlly trainings, and we said to folks that if you come to these trainings and learn, we will give you a plaque that says, I support undocumented students, staff, and their families. And you can put that wherever you like. Like I have it on my door. Right? And so a student can come and they would see that perhaps I know something, right, about undocumented students and could be a resource for them so that students feel safe to disclose that. We don't know what our students' immigration status is when we admit them. We don't require a social security number. We don't require them to tell us whether they are undocumented or not. We can learn sometimes if they're undocumented if they qualify for what's called asset. The asset bill was passed in Colorado in 2013. And Colorado joined a number of other states that allow undocumented high school graduates to, if they can show that they live in the state of Colorado and that they've been going to school in the state of Colorado, they can prove the residency requirements, essentially. They are going to be eligible for in-state tuition. For years, we had been treating undocumented students as international students, essentially, and they were paying out-of-state tuitions. And so DACA, which passed in 2012, coupled with the asset bill passing in 2013, really exploded our numbers of undocumented students at every college in this state. And so for every college to become aware of that, I think was really important for us to understand, but also making sure that we're protecting the privacy of our students. And thankfully, students are protected by the Family Rights to, what's it called? Family Right to Educational Privacy Act, right? FERPA. So our students' immigration status is And really anything related to their enrollment here at the university is protected by FERPA. And so we need to be very careful with that obligation to protect their privacy. And so when a student would disclose to us that they were undocumented, we need to be very careful about how we talked about that out loud to other people and make sure that we had the students' permission to share that if we needed to with someone else. But certainly there was real concern amongst our students about whether or not to disclose that status because you didn't know who was safe and who wasn't.
Yeah, when I first started, like there was no placards, right, of like who knew anything about undocumented students. And so it really had to be like ooh, let me like feel this person out and see if there's something that they say or the way that they interact with me that can make me feel like, oh, maybe I can trust you. And then that's when I would be like, okay, I'm undocumented, what can you do for me? Like, how can you support me? Or I need this thing, but I'm undocumented, I don't know how to navigate this. And so it was through students who were willing to disclose their status and ask certain staff members about things that we needed, that I think Dave Aragon, Violeta, and I never got to meet
Fred Anderson.
Did
you met Carew and Fernando Rios Mena?
Carew, I did not meet Fernando, I don't think, but when it was like through students like advocating for themselves and being like, hey, we need some things, and through faculty being open and willing to, one, learn, or two, have had experiences with immigration that I think really built that roadway for undocumented student support.
Yeah. One thing that CU did, which was really important, so CSU, every time you renew your DACA, now it's $555. It's a lot of money. It used to be $495, but a solid $500. So when I was in college, I remember if somebody had been like, hey, I'm gonna need you to pay $500 for this thing, I'd be like, sorry, there's absolutely no way. I have exactly $12 in my bank account. But CSU had been covering the renewal fee for their students. And when I brought that to CU agreed to cover the renewal fee for our students that are enrolled, for those students that need it. Not every student needs it, and not every student asks for it. But if a student enrolled here at CU needs help with the renewal fee, CU will cover that. It's been a wonderful thing. I'm gonna go off script a little bit with Hunter. So last semester when Hunter was in clinic was when the Trump administration came into power. And one of the first things they did is that they took away a long-standing policy that Immigration and Customs Enforcement had, that they would not perform enforcement actions at what we call sensitive locations. For many years, immigration authorities would not come into sensitive locations. That includes schools, hospitals, and churches. And when that policy was lifted, I would say there was a flurry of consternation. This is perhaps the understatement of the century. CU really freaked out. A lot of schools really freaked out. Suddenly we were going and talking. So do you remember that we went last semester and I gave a talk in the Spanish and Portuguese department at the invitation? And can you tell us a little bit about what that was like and the people that were there and sort of what the conversation was like?
Yeah, so when we did this partnership, it was our clinic and then a bunch of people from, a bunch of undergrads, and it seemed like a bunch of community members too. We were in a room that probably could fit 50 to 80 people, and it was standing room only, people out in the hallway, people wrapped around, and so many people had so many questions, and the overarching thing was uncertainty. Yeah. Between this policy and then the Lake and Riley Act, which expanded the ability for arrests alone to be basis for deportation detention. There were people in there who were just genuinely very frightened about what would be happening next. And that has been the thing that I've conveyed to anybody who asks about this. The hardest part right now is the unpredictability. That on any given day, this administration sends out a new policy, judges start acting differently, ICE starts acting differently, they start acting in new, unprecedented ways, and you could feel that in the community. The sense of reliability and predictability that many people who have been on TPS for I don't know how many years, who've had DACA for I don't know how many years, and then some people, looking, what are the other avenues that we can do to stay? Then hearing, we were talking about what type of visa, the visa for battered women?
The U visa.
U visa. Mm-hmm. And people were talking about that as like, oh, here's a potential way, and then being told that's a 15-year wait right now to have a U visa adjudicated. you could feel this sense of just like, where do we go next? But what was very, in some ways, heartening to see was that there were still people who felt safe enough coming there and talking and asking questions. So it was both sad, disheartening, but good to see that there was a community of people of varying immigration statuses who were seeking out information and building that sort of community to try and get some answers.
Right. And a lot of US citizens who are there who are just very, very concerned and trying to figure out how can we be allies. I love that. Yes? Sure.
This is for the people online so they can hear.
Oh, I understand that. Thank you. My wife and I have been sort of horrified seeing what ICE does in the way of procedures. And I'm just wondering, what are the actual laws as opposed to what the Trump administration policies are when it comes to what you need to do to arrest somebody? And also identifying yourself. We had a case down in Springs where some guy was pretending to be an ICE agent. And I mean, you get this whole thing about they're putting tape over their badges and won't identify himself in masks. And I mean, who the hell knows if that's an actual agent or not? But I'm just wondering, what do you need? Probable cause? You mentioned the Lake and Riley Act, and is that if they've had any kind of arrest for a traffic incident, a DUI, they can then be arrested and deported? I'm just wondering, what are the criteria for that? Because it seems like right now, pretty much anything goes. And that's sort of horrifying to us, but.
Right, as much as it doesn't seem so, I'd love for Hunter to weigh in, and if you have any thoughts about the craziness and the ICE arrests, please share. So the immigration system is a civil system, and that means that when immigration agents want to go and arrest someone pursuant to a warrant, they have an administrative warrant that is not signed by a judge, and there's no requirement of evidence that needs to get to a certain level, the way that we need that in the criminal system, right? In order for a judge to sign an arrest warrant or a search warrant in a criminal matter, they need to get to probable cause, right? By an officer that has been sworn in under oath and get there that way. Not the same with immigration agents. So they are able to execute warrants in public places, right? They are not allowed to go into someone's home if that person doesn't give them permission to enter. So one of the Know Your Rights presentations over the last many years have included that information to immigrant folks who may be subject to an ICE agent showing up at their door, at their house, and understanding that they are not required to let them in because the warrant that ICE agent has doesn't permit them to just come in forcefully if they refuse to open the door. That being said, ICE agents can certainly arrest people in public places, right? The question of whether or not ICE agents should have to identify themselves, I think is an obvious one. They should absolutely have to identify themselves. How many people saw the arrest of, speaking of another student, Romesa Ozturk? She was a PhD student and studying at Tufts, and she was taken into custody last semester. We were all in class. She was on her way to brunch to meet some friends. She's originally from Turkey. She's here on a student visa. And she was surrounded by a bunch of people who were not easily identifiable as law enforcement agents. Many of them had their faces covered. They didn't have any emblems or insignias of being law enforcement agents. They pulled up in an unmarked van, and she told people afterwards that she thought she was being kidnapped. And they hustled her into the van, and it was only until after they left and took her away that she understood that she was in immigration custody. And so, of course, we're seeing this happen across the country, right, is unidentified ICE agents wearing masks, right, not clearly showing who they are, arresting people. Certainly California has stated now, is it all of California or is it one jurisdiction in California? It's like you have to identify yourselves and you cannot wear a mask when you're conducting enforcement operations. This is obviously stuck in the courts. The lawyers are very busy.
Yeah, and to add on a couple other things that are kind of new that I have been following on the technology side because they're very concerning to me from a Fourth Amendment perspective. There has been pretty good evidence that ICE agents are going around using phones to do facial recognition of individuals, that they are just putting a phone up to people's faces, scanning them to determine their immigration status. 404 Media, who, if you are interested in privacy concerns, somebody I would recommend following. They're a great organization. They have FOIA'd or gotten their hands on some documents that says that DHS is going to maintain that facial recognition information for 15 years. You, as a citizen, do not have the opportunity to opt out of that collection of your biometric information, and that they are planning to put that into a database of citizenship and non-citizenship. I don't know what right now can be done about this. Are you all familiar with the case of Bivens in Section 1983 civil rights cases? That was kind of the start, a hope that there could be some freestanding causes of action to sue federal officers for violating your constitutional rights. But unfortunately, over the past years, in a few different cases, Egbert v. Boole, Teco v. Vega, the Supreme Court has done everything they can to say that you really can't use 1983 to sue federal officers for violating your constitutional rights. At the Institute of Justice, a civil libertarian nonprofit legal organization, they have been using the Federal Tort Claims Act to try and hold some individuals accountable, and they've had some pretty good success in using the Federal Tort Claims Act to bring causes of action against against federal agents. Outside of that, it's tough right now. The American Immigration Council has a little red card that they prepare to have you know your rights. I encourage you, if you want to, hey, how can people know what their rights are? The American Immigration Council has really good resources that are available, printable, that you can distribute to individuals in your community who might be curious about what they can and can't do when an ICE agent seeks to approach them.
We have about 10 minutes left. I'm going to ask our panelists one more question each, same question. Brenda, what is one thing that you would change about our immigration system if you had a magic wand?
If I had a magic wand, probably more pathways and more clear pathways. My family came here in 2000. My uncle is a US citizen. My dad thought this could be like hope for us to be able to like have a pathway to citizenship. 25 years later, his application was able to be submitted. I think is how that goes. Yeah. 25 years. My dad has not stopped working a day in his life because he has to work for himself. Same with my mom. And as their daughter who immigrated with them, I'm like, we have worked so hard and feel like we have to prove ourselves every single day to be like, we belong here. And that's because there are virtually no pathways, very, very limited pathways that are hard to understand and to navigate. And so if I had a magic wand, having more pathways that were clear and available to people, I think would be my fix.
Hunter.
Yeah, I kind of said what, I have one very radical, one a little less radical. One, the radical position that I take is that immigration law is based on the plenary authority. That is a non-textually based constitutional principle that says a government is sovereign and therefore they can just do this. That's not how our country works. Our country is a limited government with limited powers written in the Constitution, and I would just undo the plenary power. Then this immigration context would be much more difficult to have because we would have to sit down and come together as a democratic government and actually make the rules instead of what we have allowed to be done, which is the federal government can kind of just do whatever it wants. The Constitution doesn't apply as rigorously to individuals, despite the text of the Constitution, 4th, 5th, no person, no person, no person. It doesn't seem to matter for citizenship. That's my radical position. I think that's not going to happen anytime soon because that would also impact American Indian law and how we deal with our territories. Don't think that's going to happen in any of our lifetime. The less radical position is the right to counsel in immigration matters. I think there is very, very good evidence that's been presented that when you do have counsel, whether it is in criminal or civil matters, people get better outcomes. And they get better outcomes because their rights are better vindicated. People are not abused. And I think in a room full of lawyers, we would all understand the importance of the right to counsel. So what I would like to change is that in immigration matters, you get the right to counsel. I think a lot of these things would become much more difficult to do if people had an attorney, if they could not afford one.
Yes, love it. in the time we have, questions? Veronica.
So I don't practice criminal law. I'm an employment attorney, and some of my clients are undocumented, and the general advice I've gotten is, settle their cases quickly. Don't file those cases because it exposes them to risk from the immigration system. So I'm curious, like, how realistic is that? That fear, and if you've ever come across it too, if that's really like what we should be doing for our clients who don't have a status.
The advice is to settle their employment case quickly so that they don't get exposed to immigration? So
settle the case quickly. Don't file the case in court, because if you file it in court, it becomes public record, and then they're subject to danger, basically.
Yeah, potential sort of identification. Certainly it is, I think, everyone's top concern to avoid unnecessarily exposing non-citizens to the wrath of immigration and customs enforcement these days. Whether or not I think that their case being filed in court and it would be a matter of public record, I mean, yes, any exposure or any sort of public space would increase your client's exposure for someone who's looking. And obviously we have an immigration system that is very, very aggressive right now. I think we are waiting for the shoe to drop here in Colorado for them to really, really sort of put on the full court press. I think it's going to get a lot worse before it gets better. I mean, we have clients in the clinic. I told you we're handling 6 misdemeanor cases. All of them right now are out of custody. None of them are in criminal custody and are not in immigration custody. I am waiting, right, for the day when immigration and customs enforcement agents show up at the courthouse to get them, despite our Colorado law that was passed in 2024, which prohibits civil arrests in Colorado state courthouses. The immigration agents are starting to do it. And so these folks are, their criminal case is a public record. So immigration agents, if they're looking for it, could certainly come and find them. And some of our clients who are completely undocumented could then be arrested and put in immigration detention simply because they're undocumented and don't have the proper paperwork to be here. And if they entered the country unlawfully, one of the big changes that we've seen starting in September of this year is that the immigration judges are taking the position that they're not eligible for bond. Right? Even if they've been here for 30 years and have been working hard and paying taxes and have U.S. citizen children, they are taking the position in immigration court that they're denying them bond. Now, it's been temporarily enjoined, thankfully, to my friend Hans Meyer and the ACLU here in Denver, right? But who knows when that's going to be overturned, if that's going to be it. But we're seeing such extraordinary things of people being taken into immigration detention. We're seeing the immigration court system do things that we've never seen them do before.
Along those lines, if I could interrupt, there's a question from someone online. What currently happens to real and personal property owned by anyone detained or deported?
So it varies from person to person. Immigrants who are deported from the United States are not allowed to get, like if they're deported from detention, their family can't bring them like a suitcase full of their clothes. They literally will leave the United States with a garbage bag full of clothes. What happens to their property here in the United States is sort of up to them and the family members that have been left behind to sort of handle it, right? So I think we're certainly changing the way that we talk to people about the planning that they need to do before they, if and when they are detained. But this happened during the first Trump administration as well, where we spent a lot of time talking to families who are most concerned about what happens to their children should they be detained. And what are the plans that they need to put into place. So sometimes that's designating someone who will take care of the kids, right, and go get them from school if you happen to be detained and you weren't anticipating that. People are also thinking about, like, who am I designating as power of attorney so that I can have someone who's going to handle sort of my house, right? There's so many millions of immigrants that have been contributing to this economy for a very long time, and they own homes, right? They own cars, they own businesses, right? Like, who is going to handle that? And certainly immigrants have been, for many years, sort of taking those threats, right, from the federal government very seriously. We're now seeing it unfolding in real time, and definitely people are getting their things together to anticipate that kind of thing. Thank you, everyone. I so appreciate the engagement. Thank you to our panelists as well.
Thank you. We're so blessed, really, to have this expertise right here at the law school. I am grateful to each and every one of you for presenting today. We do have the barbecue starting, and I was told to let you know, if you're staying for the barbecue, you get 2 drink tickets. You just have to go to the registration table underneath the tent to get your 2 drink tickets. So one last round of applause.
Thanks, you too.
Thank you.